All rise. Voulez-vous lever? Please be seated.
Well, good afternoon. We will now proceed with the prosecution's response. Counsel, you will have 1 hour and a half, as it was anticipated this morning. After that, we will have a break, and then we will hear the defense replies. So you can start. Thank you.
Thank you, Your Honors. Your Honors, Stanišić and Simatović have failed to show any errors in the trial chamber's conclusion that they aided and abetted the ethnic cleansing crimes committed by Serb forces in Bosanski Šamac. The trial chamber's findings are consistent with the law and amply supported by the trial record. As you will hear tomorrow, the prosecution's position is that they should have been convicted for much more. Both Stanišić and Simatović were high-level leaders in the Serbian state security, sometimes called the secret police. This was the espionage department of the Serbian Ministry of the Interior, responsible for intelligence and counterintelligence. And like other intelligence services, they operated in secret. The chamber found that Stanišić and Simatović formed an elite paramilitary unit, a unit that operated under their exclusive authority, whose members participated in ethnic cleansing. Stanišić and Simatović also established a network of training centers across the region, where they trained other Serb forces who participated in ethnic cleansing across Croatia and Bosnia-Herzegovina. And in April 1992, Stanišić and Simatović deployed their elite paramilitary unit, along with local fighters who had just completed their special training, into the violent ethnic cleansing operation aimed at removing non-Serbs from the municipality of Bosanski Šamac. The group sent by Stanišić and Simatović, together with the JNA, Serb police, and territorial defense, attacked the town. And in the course of this operation and its aftermath, Serb forces, including unit members and those under their command, committed violent crimes against the non-Serb population. Through murders and rapes and other forms of sexual violence, arbitrary detentions, beatings, and torture, looting and destruction, ultimately the attackers forcibly displaced the non-Serbs from their homes and communities. This attack on Bosanski Šamac was not an isolated event. It followed the same pattern of crimes that Serb forces had been committing for months, first in Croatia and then in Bosnia-Herzegovina. At paragraphs 605 and 607, the chamber correctly found that the accused provided practical assistance that had a substantial effect on these crimes, and that they did so with the necessary intent, and it convicted them for aiding and abetting. The appellants show no error. Today, Your Honors, I will focus my response on the arguments presented by counsel for Jovica Stanišić. Where both appellants have raised common arguments, I will address them together. And then my colleague, Ms. Bolton, will respond to the remaining arguments presented on behalf of Mr. Simatović. In our presentations, we'll try to focus on the matters raised by the defense this morning and the matters that are in the reply briefs. But for our detailed responses across the entire 2 days of the hearings, the prosecution relies on its briefs. To give you a bit of a roadmap I plan to first address the legal standard for the mens rea of aiding and abetting. This is ground 3. I will then respond to the factual submissions on mens rea, ground 4. And then I'll address some points relating to ground 1 and 2 concerning the actus reus of the crime of aiding and abetting. And finally, I'll make some brief submissions on sentencing grounds 5 to 8. I'll start with Stanisić's third ground of appeal regarding the legal aspects of the mens rea for aiding and abetting. Your Honors, the legal test for the mens rea of aiding and abetting is settled. The parties agree that the required mens rea standard is one of knowledge. And the Chamber applied this test correctly when it found that Stanišić knew his conduct would assist the commission of the crimes in Bosanski-Shamats. And you can find that at paragraph 607. I will first address the meaning of knowledge in customary international law, and then I'll turn to the question of how specific this knowledge needs to be in relation to the crimes. The mens rea standard under customary international law has always been one of knowledge. And again, this is what the Chamber applied. And the Chamber's findings make clear that the accused had actual knowledge that the crimes would occur. It found at paragraph 607 that the prosecution had proved beyond a reasonable doubt that Stanišić and Simatović knew that their acts assisted in the commission of murder, deportation, forcible transfer, and persecution, and were aware of the essential elements of the crimes, including the intent of the perpetrators. This is a finding of actual knowledge. It's not just a knowledge of a risk. And this finding is soundly based on the extensive evidence showing that Stanišić was exceptionally well informed about the ethnic cleansing intentions of the members of the JCE and the prior pattern of crimes that had been committed by them. And I intend to return to the evidence underlying those findings when I move to ground 4. So, because the Chamber's findings are of actual knowledge, it is not strictly necessary to address Stanisić's arguments about the mens rea requirement. But it is important to the case as a whole. So I want to point out that the knowledge standard in customary international law does not and cannot require absolute or even virtual certainty. Knowledge of a probability of the crimes occurring is enough. And in saying this, the prosecution is not attempting to lower the mens rea standard, as Stanišić argues. Knowledge includes and has always included an awareness of a probability. In the jurisprudence of this tribunal, this level of awareness is referred to as indirect intent. No aider and abetter could ever have perfect certainty in advance that the principal perpetrator will actually commit the crimes or use the assistance provided. It would therefore be unreasonable to require an aider and abetter, a person who does not have control over the crime, who is an accessory to the crime of somebody else, to have virtual or absolute certainty. And the recognition of this in the case law is demonstrated by the repeated clarification that the aider and abetter only has to be aware of that one of a number of crimes will probably be committed. And I would refer your honors, for example, to the appeals judgments in the Stanišić case at paragraph 1772 and Popović at paragraph 1751. Your honors, it's true, as my learned colleagues point out, that the jurisprudence often states the mental element for aiding and abetting in two pieces: knowledge that the acts will assist, and awareness of the probability that the crimes will occur. While this can be helpful in a theoretical way, it's obvious that the first prong's reference to knowledge cannot be absolute or perfect knowledge, given that it relates to a future crime that is only required to be a probability. The knowledge standard for aiding and abetting in customary international law therefore includes an awareness of a probability or awareness of a substantial likelihood. And both terms, the awareness of the probability on the one hand and awareness of a substantial likelihood, have been used interchangeably in our case law to express an awareness of a heightened level of risk. And Your Honors, I acknowledge that sometimes these terms are used in a way that is different than in national jurisdictions. But what is important is that this level of knowledge is sufficient to demonstrate that the accused person has indirect intent and that the accused has accepted the risk or the crime. And for the underlying theory on this, I would refer you, for example, to the Blazkowicz appeals judgment, paragraph 41 and 42. And I would also refer to the MICT-15 appeals judgment, paragraph 101, which applied the probability standard. I want to be very clear on this. The prosecution is not arguing that the mens rea standard is an awareness of a possibility or reckless or ought to have known. An awareness of a heightened risk is not equivalent to the common law concept of recklessness or the civil law concept of dolus eventualis. Both of these standards are lower than the indirect intent in customary international law. So to sum up, the Chamber correctly applied knowledge as the legal standard for aiding and abetting liability. It found that both accused, Stanišić and Simatović, had actual knowledge, but even an awareness of the probability would have been enough. Let me turn now to the specificity of this knowledge. The Chamber correctly assessed whether Stanišić knew that his conduct assisted the crimes of persecution, murder, deportation, and forcible transfer. And the Chamber found that he knew that the operation that was planned for Bosanski-Szamats was not only a military operation. Instead, at the time of the training and deployment, Stanišić knew that his contributions were supporting the commission of the crimes. No more specificity was required. And I would refer Your Honors to paragraphs 418, 419, and 607. And in line with the relevant case law, the Chamber analyzed whether Stanišić knew his conduct would assist the specific crimes in Bosanski-Szamats understood as the type of crime. The Appeals Chamber addresses this at paragraph 1773 of the Stanišić appeals judgment. There, the Appeals Chamber confirmed that the reference to specific crimes in the aiding and abetting mental element referred, for example, to, and I'm quoting, murder, extermination, rape, torture, wanton destruction of civil property, etc., the types of the crimes. That same paragraph goes on to explain that there is no legal requirement for the aider and abetter to know every detail of the crime that was eventually committed. And the Appeals Chamber in Popović confirms again that aiding and abetting liability does not require knowledge of the specific detail of the crimes. The Chamber's analysis properly focused on the accused's knowledge of the type of crimes that were included in the criminal plan, so murder, persecution, deportation, and forcible transfer. And contrary to the suggestion, the chamber was not required to find that the accused had any advance knowledge that specific criminal incidents would occur, or that or have knowledge of the individual perpetrators that would be involved. Stanišić has failed to show a legal error in the chamber's application of the mens rea for aiding and abetting, and ground 3 should be dismissed. I'll turn now to Stanisić's fourth ground of appeal concerning the chamber's factual assessment of the mens rea for aiding and abetting. The chamber was reasonable when it concluded that Stanišić had the mens rea to aid and abet the crimes in Bosanski Šamac. In reading the judgment, Stanišić seems to disregard the chamber's analysis of intent in the JCE section of the judgment. But this analysis is clearly incorporated into the chamber's aiding and abetting reasoning in paragraphs 606 and 607. The chamber correctly found that the attack on Bosanski Šamac was in furtherance of a common criminal plan. Judgment paragraphs 377 to 379 and 606. A plan that had been in place from at least August 1991, around 7 months prior. That's judgment paragraph 379. And that had already resulted in ethnic cleansing crimes across the region. At paragraph 418, the chamber found that Stanišić knew that he was supporting the commission of the crimes. And as chief of the Serbian state security, it was his job to know. The chamber found that he had unparalleled access to information about the events on the ground in Croatia and in Bosnia-Herzegovina, including the commission of the crimes. Paragraph 586. Prosecution Exhibit 2792 is an intercepted conversation from 28th of January 1992, around 6 weeks before the group began their training for the Bosanski Šamac operation. Stanišić told Bosnian Serb political leader and JCE member Radovan Karadzic, quote, "I don't know how much you know, but we know everything," end quote. The crimes in Bosanski Šamac were not an aberration. They were consistent with the pattern of crimes that was being perpetrated across the region pursuant to the criminal plan. The chamber found that commencing in August 1991, JCE members repeatedly deployed the JNA, the army, alongside other Serb forces in a series of coordinated attacks on towns and villages in Croatia and Bosnia-Herzegovina. And these coordinated operations followed an organized pattern that repeatedly involved violent crimes. Serb forces took over towns and villages and violently drove out the non-Serb inhabitants. During and following these takeovers, Serb forces acted with brutality. They killed and beat and sexually abused and arrested and detained non-Serbs. And as they cleared the villages, they raided and burned homes and religious buildings. Contrary to what you heard this morning, these Serb forces were not unrelated to the Bosanski Šamac operation. They included, for example, the JNA and the SAO-SBWS police. The chamber reasonably concluded that the Bosanski Šamac operation followed this same pattern, and that the campaign of violence and terror left the non-Serb population no choice but to leave Bosanski Šamac. Paragraph 375. Just as the non-Serbs had been forced to leave communities across Serb-claimed territories during the preceding months. Stanisić's knowledge of the crimes is not affected by the group's resubordination to the JNA during the operation. The chamber found that Stanišić knew what the JNA had been doing in all of the other places where the JNA was directly involved in ethnic cleansing in location after location for months on end. And the chamber found that Stanišić was aware of the shared intent of Slobodan Milosevic and other senior military leaders who led the JNA. The hypothetical suggestion that the group could have been commanded in a manner contrary to Stanisić's awareness or intent, made at paragraph 47 of the appellant's brief, is disproved by the evidence and by the chamber's factual findings. Given Stanisić's level of knowledge and awareness of the ethnic cleansing campaign that had been going on since August, including the JNA's involvement in these crimes, it is implausible and illogical that he could have believed that the training and deployment would only further legal activities. Your Honors, as counsel reminded you this morning, Stanišić accepted at paragraph 97 of his reply brief that if Stanišić was shown to have known that the Bosanski Shamac operation was in furtherance of the common criminal plan, then the requisite knowledge of crimes would be established. Your Honors, this is exactly what the trial chamber found, and ground 4 should be dismissed. Your Honors, I'm turning to the next section on the actus reus. Counsel did not make many submissions this morning on the actus reus. Instead, he made a notice point and argued that the prosecution was unable to show a substantial contribution because our original substantiality case had allegedly failed. I'm going to start with this notice issue and then turn to a couple of points on the legal test before addressing some of the factual challenges. Starting with notice. This is not actually a notice issue. All of the contributions found by the chamber fell squarely within the indictment's charges. As explained at paragraphs 79 and 80 of the prosecution's reply brief, the indictment met all of the pleading requirements, including for aiding and abetting. So Stanišić was on full notice of the scope of the allegations against him. Contrary to his suggestion, the substantiality of his contributions is not to be measured against the percentage of the prosecution's case that is ultimately proven. The fact that the prosecution was not able to establish all of the allegations does not make his contribution less than substantial. The test is whether the conduct substantially assisted the crimes. And the culpability link that Stanišić is seeking is found here in the requirement that the requirement of proof that the accused conduct had a substantial effect on the crimes. Your Honor should reject Stanišić's suggestion that the requirement of a substantial contribution should be interpreted more strictly in one type of case involving a so-called remote accused, and less strictly in another case involving an accused who is on the scene. This would introduce uncertainty, and it would lead to potentially perverse results. It does not make sense, Your Honors, for the law to be harsher towards those on the ground and more lenient towards the higher level but more physically remote perpetrators. As a matter of principle, the same scrutiny should be applied whether the aider and abettor is standing next to the direct perpetrator or whether he is training them and deploying them into an ethnic cleansing operation. Your Honors, the chamber reasonably found that by organizing the training and deployment of a group of around 50 men into the Bosanski Shamac operation, Stanišić and Simatović aided and abetted the crimes by providing practical assistance which had a substantial effect. The measurement of a substantial effect is not just a question of numbers. In theory, the deployment of a single person can be substantial. For example, when that person is the one perpetrating the crime. So the deployment of group members who personally committed crimes is obviously a substantial contribution to that crime. The Blagojevich and Jokic appeal addressed a similar issue. Both appellants argued that their practical assistance was inconsequential in the overall context of the large number of Serb forces involved in the massive Srebrenica crimes. The appeals chamber addressed the chamber's conclusion that the scope of their assistance was more limited compared to other groups. But it reaffirmed that assistance does not have to be a condition precedent, and it upheld their convictions for aiding and abetting, emphasizing that the question of whether an act constitutes substantial assistance to a crime is a fact-based inquiry. That's a Blagojevich and Jokic appeal, paragraph 134. And the chamber conducted this fact-based inquiry that the appeals chamber jurisprudence required. It reasonably concluded that the training and deployment substantially assisted the crimes. Stanišić claims in his reply at paragraph 40 that the deployment was, quote, nothing more than making the group available to the JNA. And today he describes this contribution as de minimis. But what Stanišić is trying to minimize was in fact of substantial assistance. It amounted to aiding and abetting the crimes. There can be no doubt that the training and deployment of the group facilitated the crimes committed in Bosanski Šamac. But for this deployment, these men would not have participated together as a group under Cerny's command, and unit members would not have been able to commit crimes, beating and abusing detainees, massacring 16 non-Serbs in the Crkvina detention facility, and they wouldn't have been able to support the crimes of other Serb forces. Cerny, who the evidence shows was in charge of the group and had authority over JNA soldiers, himself participated in beating detainees. Trial judgment, paragraph 223. And the unit's brutality was notorious. They were referred to in Bosanski Šamac as masters of life and death, and were universally feared even by their fellow Serb fighters. And I would refer you to the evidence discussed in paragraph 210 of the judgment. As the chamber correctly concluded, any resubordination to the JNA during the operation did not break the causal connection. Stanišić and Simatović formed the group through the training and the deployment into the operation. And in Blagojevich and Krstić, the ICTY appeals chamber acknowledged that the actus reus of aiding and abetting is satisfied when a commander permits the use of personnel to facilitate the perpetration of a crime. That's Blagojevich, paragraph 127, and also the Krstić appeals judgment, paragraph 144. By training the group and making the group available through the deployment, Stanišić and Simatović aided and abetted the crimes in Bosanski Šamac. They provided trained ethnic cleansers to an ethnic cleansing operation. The appellants have failed to show that the chamber made any error, and Stanisić's ground 2 and Simatović's corresponding arguments on this point should be dismissed. Your Honors, I'll move now to Stanisić's challenges to sentencing, which is grounds 5 to 8. Your Honors, grounds 5 to 8 of the appeal should also be dismissed. Stanišić fails to show any discernible error in the chamber's exercise of its discretion. Let me remind Your Honors that Stanišić declined to make sentencing submissions at trial. He therefore cannot complain on appeal of any failure to consider evidence and arguments that he did not put before the chamber. And on top of this, he wants you to correct the chamber for failing to rely on evidence that was not even admitted. The chamber did not err in refusing to consider evidence that was outside of the trial record. For the chamber to have done so would itself have been error. And Your Honors, we have addressed his claims of being a peacemaker throughout the conflict. I'd refer you to the contrary evidence, including his contemporaneous threats to exterminate them all. And that's found in P-2790. For the prosecution's response to arguments about provisional release and length of proceedings, I would refer you to our briefs and to the arguments of Ms. Bolton, who will address these matters primarily in connection with Simatović's appeal. In short, the chamber did everything that it was legally required to do. It considered the gravity of Stanišić's crimes, including the role that he played in their commission. It analyzed the aggravating and mitigating circumstances, including by considering possible mitigating circumstances that Stanišić did not even advance. It took into account the sentencing practice in the former Yugoslavia, and it considered sentences in similar cases. And it provided reasons for its analysis that are sufficient to explain why it imposed a 12-year sentence. Stanišić disagrees with the outcome of the chamber's discretion, but the sentence is not manifestly unreasonable. On the contrary, Your Honors, nothing less than a 12-year sentence would reflect the gravity of the chamber's conviction. Grounds 5 to 8 should be dismissed. Your Honors, unless you have any questions, this concludes our response to Stanišić's appeal, and I would pass the podium to my colleague, Ms. Bolton.
Ms. Bolton?
Has already addressed Your Honors on the relevant law pertaining to the mens rea and actus reus of aiding and abetting. And she has explained how the training and deployment of the group amounted to a practical assistance amounting to a substantial contribution to the crimes. Those submissions apply equally to Simatović. Simatović has failed to demonstrate any error that would warrant overturning his convictions or reducing his already lenient sentence. His appeal is a thinly veiled attempt to retry the case before this chamber. He raises few issues of law, instead expressing disagreement with the trial chamber's findings of fact and credibility assessments without demonstrating error. To succeed in overturning a conviction based on factual errors, an appellant must demonstrate the error or errors are capable of creating a reasonable doubt as to his guilt. There was no one finding of fact that was determinative of Simatović's guilt. He would have to convince Your Honors to set aside a large number of the chamber's factual findings to succeed on appeal. He has not met that burden. Today in oral submissions, Simatović has repeated many of the arguments he made in his appeal brief. And in the process, he has made numerous misstatements regarding the underlying evidence. It will not be possible to address all those errors in my responding oral submissions. I will address those arguments. So we have already addressed many of those arguments in our response. For example, you will find our response to his submissions regarding the trial chamber's alleged inconsistencies in its findings regarding the composition of the group at paragraphs 60 to 61 of our response. Similarly, his argument regarding Pajos being run by the Iraq military administration is addressed at paragraph 72 of our response in the last bullet point. Today, I will first begin by responding to Simatović's ground 2.8. This is the argument that he lacked the requisite intent. I will then briefly respond to a new argument he has raised in relation to grounds 2.9 and 2.10 in his reply brief. Third, I will turn to his many challenges to the Chamber's factual findings in relation to the training and deployment of the group. And that is where I will address his credibility challenges to RFJ 035 and Todorović, and also his attempts to portray himself as a minor player in the Serbian State Security Service. And finally, I will have some brief comments to make with respect to his sentence appeal. Some of those submissions, particularly with respect to the length of proceedings, also apply to Stanišić. Turning to my first issue, intent. Today, Simatović asserted he was not aware the group would commit crimes in Stanišić. He made comments to the effect that there was no evidence the troops were trained for the purpose of committing crimes. Simatović has failed to demonstrate the Chamber erred in finding that he knew that by training and deploying the group, his conduct would assist the commission of specific crimes by Serb forces in Stanišić. As Ms. Bagg has just discussed, the Chamber found that at least by August of 1991, a common criminal plan existed to violently and permanently remove non-Serb civilians from large areas of Croatia and Bosnia-Herzegovina through the crimes of murder, persecution, deportation, and forcible transfer. The Chamber also found that Stanišić and Simatović were aware of that plan and the criminal intent of the JCE members. The Chamber found that takeover operations in Croatia and Bosnia-Herzegovina followed a repeated and organized pattern. During and following the takeover of towns and villages, armed groups, including frequently the JNA, would engage in killings, beatings, and other persecutory acts of violence targeting the non-Serb population. And this pattern was evident long before the group's deployment to Stanišić. As a senior intelligence officer with some 13 years of experience, Simatović had unfettered access to information about events in Croatia and Bosnia-Herzegovina. The Chamber found that he possessed an extensive and detailed knowledge of the events that were unfolding during the indictment period. These were reasonable findings. Not only was Simatović an experienced agent, but he was on the ground in the Serbian autonomous regions of Krajina and SBWS for months preceding the events in Stanišić. The Chamber found he was involved, for example, in supplying the SAO Krajina police with cash, weapons, and technical equipment. He participated in planning and carrying out the attack on Lovinac. He was involved in arranging for State Security Service personnel to act as instructors at Golubic. And, of course, he was involved in establishing State Security Service training camps at Lezhimir and Pajos and forming a combat unit. And he was doing all of this right when the pattern of ethnic cleansing operations by Serb forces first emerged in the SAO Krajina and SBWS. Further, as you'll hear more about tomorrow, the unit was directly involved in ethnic cleansing operations in Western Srem in the fall of 1991. During those operations, the JNA, acting in coordination with other Serb forces, harassed and abused the non-Serb civilian population. Locals, the JNA, and volunteers killed non-Serb inhabitants, looted and burned their homes, terrorizing the non-Serb civilian population, forcing them to flee. The evidence showed that Simatović was coordinating with the JNA before the unit's deployment. And it also demonstrates that both Stanišić and Simatović met with unit members on the ground after the operation. Your Honors, Simatović had to have known that ethnic cleansing crimes had occurred. The absence of evidence that Simatović received written reports about the ethnic cleansing crimes that had already taken place by mid-April 1992 is not surprising. Simatović worked for the secret police, and the unit's activities were meant to be covert, and I would refer your honors to the findings of the chamber at paragraphs 326 and 334. And here I would also remind your honors of the chamber's finding that Stanišić took steps to conceal Simatović's covert activities in the Krajina in 1991, which is the period when the unit was formed. And he did so by falsifying a portion of Simatović's personnel file. And I would refer your honors to paragraph 351 of the judgment for that finding. To someone with Simatović's wealth of knowledge, the events that unfolded in Stanišić during and following the takeover were entirely predictable. The chamber did not engage in impermissible speculation in finding he possessed the requisite intent. Like Stanišić, he knew full well that the men he trained and deployed would be involved in the commission of crimes of murder, persecution, forcible transfer, and deportation. He knew he was deploying trained personnel to an ethnic cleansing operation. Simatović's ground to 8 should be dismissed. Turning now, your honors, to the additional argument Simatović has raised in his reply with respect to subgrounds 2, 9, and 10. At paragraph 91 of his reply, Simatović incorrectly suggests that the prosecution took the position that the 30 former SAO SBWS police officers were only unit members between mid-March and mid-April 1992 while they were training at Lezhimir and Pajos. Stanišić has raised a similar argument at paragraph 74 of his appeal brief, where he argues he had only a, quote, momentary, unquote, relationship with the newly recruited unit members. To be clear, the prosecution has consistently maintained that these 30 men remained unit members after they were deployed to Stanišić and resubordinated to the JNA during the takeover. And I'd refer your honors, for example, to paragraph 141 of our response. The record showed that multiple unit members who were deployed to operations in Stanišić under Cerny maintained a connection to either Stanišić, Simatović, or the State Security Service for the remainder of the indictment period. For example, both Cerny and Dabili remained in communication with and received materials from Simatović, even while the two men were serving respectively as Commander and Chief of Staff of the VRS's 2nd Posavina Brigade. Similarly, Luger, Trolja, and Avram received payments from the Serbian State Security Service in 1993 and or 1995. Regrettably, as a result of the erroneous focus of the trial chamber on contributions that were linked to charged crimes for JCE culpability, the chamber declined to make findings on the continuity of the unit. You'll find that at paragraph 390 of the judgment. In any event, your honors, the duration of their membership in the unit following the deployment is irrelevant to the convictions for aiding and abetting. The chamber found that Stanišić and Simatović contributed to the crimes by training and deploying the group. Their subsequent subordination to the JNA is immaterial, and you'll find that at paragraph 605 of the judgment. Turning now to address Simatović's many challenges to the chamber's findings of fact. I'll be addressing 4 points. First, I plan to address Simatović's attempt to portray himself as a minor cog in the wheel of the Serbian State Security Service. Second, I'll have some remarks to make about his credibility challenges. Third, I'll be asking your honors in assessing the reasonableness of the trial chamber's factual findings to consider Simatović's own words as delivered in his coolest speech. And finally, I'll have some remarks about the many evidentiary errors in Simatović's briefs. Turning to my first point, Simatović's alleged powerlessness. At paragraphs 354, 386, and 388 of the judgment, the Chamber found that throughout the period covered by the indictment, Simatović held high-level positions within the State Security Service with significant power and authority. And contrary to the position my friend made, or arguments my friend raised today, it is clear that when paragraph 354 is read in its entirety, that the Chamber understood exactly what Simatović's position was at the time of the Stanišić operation. In reaching their findings about Simatović's position, the trial chamber considered extensive argument from both the prosecution and defense, as well as the evidentiary record. The chamber's finding is, of course, relevant to the question of sentence. It is not, as Simatović has suggested both in his reply and today, relevant to the reasons for conviction. He was not convicted based on his rank. He was convicted because he knowingly trained and deployed men to take part in an ethnic cleansing operation where they committed additional crimes alongside served forces. And those convictions were based on witness and documentary evidence proving Simatović's direct involvement. Simatović's arguments in subgrounds 1, 1, and 2 seem to boil down to this. He could not have formed, trained, and deployed the group because he lacked the legal authority to do so, and because he was a low-level manager who was supposed to be monitoring U.S. intelligence in Belgrade. First, I'd note that the chamber found Simatović did not act alone. He acted in concert with the Chief of Service, Stanišić. Together, they formed, trained, and deployed the group. And the chamber accepted that Simatović was able to form the unit because, as they said at paragraph 628, he was cloaked with Stanisić's authority. The chamber also found that the State Security Service was required to perform its task while adhering to the principle of secrecy, judgment paragraph 334. It is therefore not surprising that Simatović's official job description did not include reference to covert responsibilities. It is also, contrary to Simatović's repeated submission, no excuse that Simatović was acting pursuant to Stanisić's orders or direction. And I would refer your honors to the ICTY statute, Article 7.4. In any event, Simatović's coolest speech suggests he was an enthusiastic participant in the work of the State Security Service and proud of what the unit had done. In reaching its conclusion that Simatović held high-level positions within the State Security Service, the chamber did not restrict itself to considering only Simatović's official position. This was a reasonable approach. The chamber's reasons, read as a whole, demonstrate it was very much alive to the fact that his official position and responsibilities did not align with what he was actually doing. Although he was nominally the chief of the section responsible for monitoring U.S. intelligence throughout 1991 and the early part of 1992, he was involved in numerous activities in the SAO Krajina and SBWS that had no apparent connection to monitoring U.S. intelligence, including establishing Serbian state security training camps and creating an elite combat unit. Simatović has demonstrated no error on the part of the chamber. His grounds sub 1, 2, and 1, 1, and 2 should be dismissed. Turning now to address my second factual point, which pertains to his challenges to the trial chamber's credibility findings. Simatović contests virtually all of the chamber's findings with respect to the formation of the unit, the establishment and operation of the training camps, and the training and deployment of the group to Stanišić. Many of these challenges, particularly in ground 2, are rooted in his assertion that the chamber should not have relied on the evidence of Stefan Todorović or RFJ 035. Contrary to his submission today, His convictions did not rest solely on the evidence of these two witnesses. Similarly, their evidence was not uncorroborated. The prosecution has made detailed arguments regarding these two witnesses in its brief, and I'd refer your honors to paragraphs 48 to 53 with respect to Todorovic and 54 to 63 with respect to RFJ 035. I'll not endeavor to repeat those submissions here, and instead just focus on issues that have arisen from reply or oral submissions. It is settled law that an appeal is not a trial de novo. The task of hearing, assessing, and weighing the evidence is left primarily to the trial chamber, as it is best placed to assess the evidence in the context of the entire record. To succeed in overturning a chamber's credibility findings on appeal, an appellant must demonstrate those findings and their assessment was so unfair or unreasonable as to constitute an abuse of discretion. Turning first to Todorovic. As you will recall, he was the chief of police in Stanišić following the takeover. As set out in detail in the prosecution's response, the reasons for judgment amply demonstrated the chamber considered all relevant arguments in assessing his credibility. Having done so, it was within their discretion to accept some, all, or none of the witnesses' evidence. At paragraphs 28 to 31 of his reply, Simatović has raised a new alleged error.
Excuse me, again, I will ask you, as I did earlier with the defense, if you could speak slowly.
Certainly.
For the record, please.
At paragraphs 28 to 31 of his reply, Simatović raises a new alleged error, which he did not include in his appeal brief. He submits that the chamber failed to make factual findings regarding events that preceded the attack on Stanišić, which he states are of crucial importance to its assessment of Todorovic's credibility. Regrettably, in his reply, he has failed to develop this argument or to provide citations or other particulars. If Simatović is alleging that Todorovic gave inconsistent testimony on the issue of who arranged for the locals to train at Pajos, the prosecution disagrees. Todorovic testified that he traveled to Belgrade in late February or early March 1992 with another municipal official, Milos Bogdanović. There, Bogdanović met with Milan Prodanic, chief of the Serbian State Security Service's 8th Administration, as well as Yugoslav Maksimović of the Military Intelligence Service. Following the meeting, Bogdanović told Todorovic a decision had been made to send 20 local men from Stanišić for military training at a camp the witness later learned was run by the Ministry of the Interior of Serbia. In alleging Todorovic gave inconsistent evidence as to who arranged for the training, Simatović has relied on an excerpt from Mladic's diary dated the 7th day of December 1992. There, Mladic has recorded Todorovic saying, quote, "I used to know Colonel Slobodan Jeremic and Božić and sent 18 men to Ilok for training," end quote. The entry does not indicate, as Simatović claims both in reply and oral submissions today, that Todorovic arranged for the training of the men through Jeremic or Božić. It merely indicates he used to know them. And we would also encourage the chamber to look at Exhibit P 1916, trial transcripts, page 23,434 to 23,437, which contains confidential testimony. Finally, Simatović mischaracterizes the chamber's decision to approach the evidence of certain prosecution witnesses, including both Todorovic and RFJ 35, with caution. Contrary to his repeated suggestion in his briefs, a finding that a witness's evidence should be approached or reviewed with caution is not the same as a finding that the witness is unworthy of belief. It is a self-instruction that demonstrates the chamber was alive to and considered the frailties in the witness's evidence. Simatović has shown no error with the chamber's assessment of Todorovich's credibility. Turning now to RFJ 035. As you will recall, RFJ 035 gave a first-hand account of being trained at Lezhimir and Pajos by other unit members before being deployed to Stanišić. And contrary to Simatović's submission today, he testified to training for 3 to 4 days at Lezhimir before moving to Pajos. The chamber cites RFJ 035's evidence at numerous places in the judgment. However, there's only one important finding which is based solely on his testimony, and that was the finding that Simatović addressed the group of approximately 50 men at Pajos on April 10, 1992, informing them of their imminent deployment to Stanišić. Although there's no corroboration for the witness's testimony on this point, it should be noted that his evidence was uncontradicted. Neither Simatović nor Stanišić produced any contrary evidence. At paragraphs 38 to 43 of his reply, Simatović argues that corroboration was required before the chamber accepted RFJ's evidence. It was not. As a matter of law, the evidence of a single witness may be accepted without corroboration, even in relation to a material fact. Tadić Appeal Judgment, paragraph 65, Kuprsić Appeal Judgment, paragraph 33, and the other citations set out in footnote 185 of the prosecution's response. Simatović has cited no contrary authority. Simatović suggested, both in reply and today in oral submissions, that the chamber may have relied on the evidence of 4 witnesses, including Dukic and Lukacs, as corroboration for RFJ 035's account of the briefing. Those witnesses are cited too in footnotes 943 and 944 of the judgment. This was not the argument the prosecution understood him to be making in his appeal brief. The witness's evidence does not pertain to the briefing. It pertains to other facts cited in the judgment to which those footnotes relate. So there is no reason to believe the chamber used the witness's evidence improperly. Finally, I wish to respond to paragraph 32 of Simatović's reply. Simatović accuses the chamber of failing to consider all of his credibility arguments, and he also misunderstands the prosecution's position on this issue. To be clear, it's the position of the prosecution that the chamber considered all 5 of the arguments Stanišić and Simatović collectively raised in their joint effort to discredit the witness. 4 of Simatović's arguments he repeated today, are addressed in the first sentence of paragraph 220 of the judgment. The 5th argument, advanced in paragraph 700 of Simatović's final trial brief, is addressed in the very next sentence of that same paragraph, albeit the chamber attributed the argument to Stanišić only. The attribution omission is immaterial. It is apparent the chamber took all credibility concerns into consideration before determining, later in that same paragraph, that it would approach the witness's evidence with caution. Having considered all relevant arguments, it was again within the chamber's discretion to accept some, all, or none of the witness's evidence. Again, Simatović has failed to show error with the chamber's credibility assessment. Accordingly, his subgrounds 2.1 and 2.2 should be dismissed, as should his repeated arguments relating to the credibility of these witnesses found in subgrounds 2.4, 5, 6, 11, 12, and 13. For my 3rd point on his factual challenges, I'd like to make a few comments about the Kula speech. A video of the speech with English subtitles is available as Prosecution Exhibit 256, and we would encourage Your Honors to view the exhibit. An annotated transcript of the speech, citing the evidence corroborating its content, was also included as Annex B to the prosecution's final trial brief. As Your Honors will recall, on the 4th day of May 1997, the appellant and other high-ranking Serbian officials, including Stanišić and JCE member Slobodan Milosevic, gathered in Kula to commemorate the creation of the Special Operations Unit. Simatović delivered a speech during those proceedings. In his speech, he lauded the unit's wartime achievements. He described the unit's contributions to the war as enormous. Consistent with the trial chamber's findings, in his speech, Simatović confirmed that in September 1991, a part of the unit traveled to Serbia where, quote, its reconstruction was conducted and high-quality professional training organized, end quote. This corroborates the chamber's findings at paragraph 406 of the judgment. Simatović also boasted that 26 training camps had been established by the State Security Service, including, quote, at Lezhimir and Elok, end quote. Your Honors will recall that the chamber found that Pajos is located in the surroundings of Elok, and the evidence established it was on a hill overlooking Elok. And I'd refer Your Honors to judgment paragraph 407 and footnotes 1644 to 1646. Simatović also told attendees that when the unit was formed, its core members included State Security Service personnel as well as volunteers from Serbia. These comments corroborate the chamber's findings at paragraphs 407 to 409 of the judgment. Further, Simatović told his audience, again in reference to the unit's wartime activities, quote, due to international circumstances familiar to us all, we were forced to operate in complete secrecy. At trial and on appeal, Simatović denies any close affiliation with the unit. Your Honors, it is no coincidence that the unit members were referred to colloquially as Frankie's men throughout the indictment period. It is also no coincidence that in describing the unit's activities during the war, Simatović told the crowd, we were forced to operate in complete secrecy. It is no coincidence that it was Simatović who was selected from amongst all former and current State Security Service personnel and unit members to make a speech. Or that Simatović, despite being an employee of a civilian government agency, often wore a military-style uniform with insignia similar to those worn by unit members. And I would refer Your Honors to paragraph 416 of the judgment for that evidence. The truth is that Simatović formed the unit, trained unit members at camps he controlled, then authorized their deployment to an ethnic cleansing operation in Bosanci Shamets. In his closing submissions at trial, Simatović argued that his Kula speech was full of exaggeration, notwithstanding the fact that much of what he said was corroborated by other evidence. Further, he alleged that someone else wrote the speech. The alleged drafter testified for the defense and denied writing it. The trial chamber did not accept Simatović's arguments. At paragraph 429 of the judgment, the chamber relied on omissions Simatović made in his speech, and the chamber explicitly referred to the speech as his speech, that is, Simatović's speech. Moving to my final argument, which pertains to inaccuracies. Before I move to demonstrate inaccuracies, I wish to just address briefly something Simatović said today about the nature of the training the men received. And this relates to his point that the training they received was not special. Your Honors, nothing turns on the Chamber's reasonable characterization of the training as special at paragraphs 214 and 422 of the judgment. The evidence demonstrated that the training prepared the participants, including both the new unit members and the local men, for the violent crimes that were to come. The training consisted of more than just general or fitness training, and even the more routine aspects of the military training were not irrelevant to the crimes. Such military training taught the group to work together under Cerny's command and in cooperation with other Serb forces on the ground, including in the military takeover that opened the door for the ethnic cleansing crimes that followed. And the evidence cited at paragraph 82 of the prosecution's response shows that the training went beyond the basics and included not only weapons handling, but mop-up operations, house searches, sabotage, and terrorism. Whether it is viewed as special or not, it included training and skills relevant to carrying out an ethnic cleansing operation. On the topic of inaccuracies, Your Honors, in both his appeal and reply briefs, he has repeatedly misstated and cherry-picked the evidence, referring only to evidence that assists his arguments while failing to acknowledge relevant evidence that undermines them. We have provided numerous examples of that phenomena in our response brief, including at paragraphs 76, 81, 136 to 137, and 142. In his reply, Simatović has repeated some of those same misstatements he made in his appeal brief. For example, paragraphs 49 to 53 of his reply, with respect to Todorović's evidence, are mere repetitions of arguments he made in his appeal brief. And you will find the prosecution's corrections and clarifications to those arguments at paragraphs 69 and 76 of our response. For the sake of brevity, I don't intend to discuss the other errors in Simatović's reply in any detail. I would simply encourage Your Honors to consider paragraph 59 of his reply brief against pages 1, 23 to 24, and 29 of Exhibit P260, and also to consider Simatović's references to the evidence of RFJ 137 in paragraphs 56 to 58 and 73 of his reply, and compare those references against Confidential Exhibit P246, page 4. Your Honors, we urge the Chamber to use caution when reviewing Simatović's briefs. Simatović's many challenges to the Chamber's finding of fact should be dismissed. Finally, a few words on the sentence appeal. The prosecution's position is the Chamber committed no errors in sentencing Simatović. However, should error be found, the sentence should not be changed. 12 years was a lenient sentence for offenses that included the brutal murders of 16 detainees in the Circovina warehouse on the 7th day of May, 1992. A lesser sentence would not adequately reflect the gravity of the offenses or the appellant's role in them. I'll be addressing only 3 of the errors that Simatović has alleged in his brief. The first is but a minor point of clarification, and it pertains to Simatović's ground 3.7. There he argues that he should have received sentencing credit for time spent on provisional release. And at paragraph 290 of his brief, he has claimed that he was not allowed to leave his place of residence while on release. To be clear, neither Simatović nor Stanišić were ever subject to a house arrest condition. The terms of their release required them to remain within the city where they were residing, but not within their homes. The conditions of their release orders were not akin to detention. Second, I wish to briefly address Simatović's related arguments in grounds 3, 3, and 4, relating again to his position within the Serbian State Security Service. The Chamber did not err in refusing to find that Simatović held a low-level position warranting mitigation of sentence, or in finding that he abused his position and authority within the State Security Service, and treating that as an aggravating factor. In advancing his sentencing arguments, Simatović, again, focuses solely on what the prosecution would say is his relatively high-level official position, ignoring his de facto powers and activities, as well as the Chamber's earlier findings. In sentencing Simatović, it's clear that the Chamber's focus was not on his nominal position. Instead, it focused on the actual role he played in relation to the creation of the unit and the training and deployment of the group to Bosanci Shamets. The Chamber expressly said as much at paragraph 629 of the judgment. The Chamber committed no error. Finally, let me turn to the length of the proceedings, and these submissions apply to both accused. The case law is clear. The length of proceedings itself is not a mitigating factor. Nahamana Appeal Judgment, paragraph 1073. However, a violation of an accused's fair trial rights may lead to a reduction in sentence. Complex international criminal trials take time. Article 21, 4C of the statute does not protect accused persons from lengthy trials per se. It protects them from trials that are unnecessarily long. The burden of proving a violation of an accused's right to trial without undue delay rests with the accused. An accused cannot complain about delays he has caused, and he must point to specific acts or omissions on the part of other justice system participants that have unnecessarily delayed the proceedings. Failure to provide those details may result in the appeals chamber dismissing the claim as unproven. Simatović made no complaint about the ICTY trial or appeals chamber's proceedings, about the length of those proceedings before those bodies. In final submissions before the mechanism trial chamber, Simatović identified only one act that he alleged resulted in unwarranted delay, and that was the ICTY appeals chamber's decision to order a retrial itself. His submission amounted to a collateral attack on the appeal chamber's decision, and the chamber was correct in ruling at paragraph 631 that it did not have the jurisdiction to consider the correctness of an order issued by a higher court. And I would remind your honors that there is nothing inherently unfair about a retrial. In referring to the ICTY appeals chamber's retrial decision in its 2nd February 2017 ruling, the trial chamber stated that the order for a retrial had, quote, effectively given the prosecution a second chance to make its case, end quote. This implies that the prosecution had failed to make its case during the original trial and was unjustly being given a second opportunity to correct those shortcomings. It also implies that the prosecution was somehow responsible for the delay. To be clear, the ICTY appeals chamber determined that a full retrial in this case was necessary because the ICTY trial chamber committed serious legal errors that could not be remedied on the existing record. And I would pause to note that those were not errors that the prosecution engendered in its submissions. The decision to order a retrial in this case did not result in unnecessary delay. The appeals chamber determined a retrial was required in the interests of justice, that no lesser remedy would suffice. And a review of the record before both the ICTY and Mechanism Tribunal demonstrates that neither Simatović nor Stanišić has made any real effort to expedite the proceedings. Although Simatović denies he has contributed in any way to the length of the proceedings, we would refer your honors to his confidential filing of 11th December 2017. We would also encourage your honors to look at Stanisić's filings on trial modality. Here I would add that Stanišić did not even respond to all of the prosecution's motions to increase the pace of the trial. For example, the 27th November 2017 motion. Your Honor, Simatović's sentencing grounds should be dismissed. This concludes the prosecution's response. Neither appellant has demonstrated any error in the Chamber's conclusion that they aided and abetted the ethnic cleansing crimes committed by Serb forces in Bosanci Shamets. Their appeals should be dismissed. Subject to any questions, Your Honor, those are the prosecution's respectful submissions.
Thank you. Questions? The appeals chamber has no questions to make, so even we are a few minutes in advance with what was planned, but we will adjourn now and we will continue in 30 minutes, so 10 to 4. We are ahead what was planned, and that is very good. Thank you very much.
All rise, voulez-vous lever?